Good afternoon, everybody. My name is Patricia Aliyah from Aliyah Associates, and welcome to our CondoWise learning series. Today we're at session 12, and it's part 1 of 2. We're going to be talking about aging both of people and infrastructure. Part 1 today is dedicated to people and dealing with aging residents, focusing more on mental illness and physical disabilities. But before we get started, I wanted to just remind you that everybody is welcome to our sessions. And since every condominium community is unique, the advice provided in our sessions is of a general nature and is not legal advice. We recommend that you consult with your condominium corporation's lawyer to make sure that the solutions determined are best suited to your condominium. So if we could advance the slide, please. I'm really pleased today to be joined by Julia White, Jonathan Wright, Ashley Winberg, and Shannon Penny from our team. Next slide, please. So some interesting statistics. Seniors are the fastest growing age group in Canada. Some of us maybe know that already. By 2036, projected to grow from 1 in 7 Canadians to 1 in 4. And will be about 10.4 million Canadians who are seniors as of 2036. As of the last census, 1 in 8 Canadian households was in a condo unit and 1.6 million households in total. So you can get a sense of the numbers of people in condominiums. Number of owner-occupied condominiums in 1981, it was 171,000. As of 2011, it was 1.1 million. So those numbers keep growing. And once I can get more statistical data, I will share that with you, but you can see the upward trend. Next slide, please. So when we look at people aging, and this is an excerpt from a presentation we did with CCI Golden Horseshoe, there are effects of aging first on the individual, mental health issues, social issues, physical well-being, and financial impacts. Next slide, please. But then there are further effects of aging. If we expand our circles and connect the dots, we see lifestyle changes, impact on partners and family through financial responsibilities, and then caring for aging or sick partners and how that impacts also family members living in our condominium community. Next slide, please. So finally, when we look at the community that we create, we also need to think about the integration of all these elements: social services, accessibility, healthcare services, and policies and procedures. Governance does directly impact how we run the condominium, and it's good to have protocols and policies in place to help us do this as our communities age. But before we get into the in-depth conversation around aging and its impact on people, I'm going to turn to Shannon, and Shannon's going to give us a brief update on the pandemic. Next slide, please.
Thank you very much, Patricia. So good afternoon, everyone. So as I am sure you're all aware, Ontario is currently in step 3 of its reopening plan. And as of today, over 83% of the population in Ontario aged 18 and older have received at least 1 dose of the vaccine, and over 76% have received their second dose. So the province previously stated that we would remain in step 3 until at least 80% of the eligible population had received 1 dose of the vaccine and 75% had received their second dose. However, in response to the evolving data around the Delta variant, and based on the recent experiences of other jurisdictions, the province decided to pause exiting step 3 of the reopening plan, and all existing restrictions will remain in place until such time that it is deemed safe to exit step 3. So the topic on everyone's mind right now is vaccine passports and whether Ontario will make them a requirement for individuals to enjoy non-essential activities such as indoor dining, going to the gym, or attending a concert or a sporting event. So Premier Doug Ford had previously rejected the idea of a vaccine passport in Ontario. However, pressure continues to build for the government to introduce some sort of vaccine passport across the province. In light of Quebec's announcement that it would implement its own passport system, it sparked a surge in new vaccine appointments. And that is what some medical experts want to see in Ontario. British Columbia have also announced that they will require patrons of non-essential businesses to be vaccinated against COVID-19 from September 13th, which the government announced on Monday. So local health units in Ontario could come up with their own vaccine passport if the province continues to resist, according to a head of a group representing local health agencies in the province. Peel Region's Medical Officer of Health, along with many other regions, have also expressed support behind the vaccine certificate program, saying that they'll also explore local options if the province didn't step up to implement a vaccine certificate program across the province. The momentum for a vaccine passport system has led to the Ontario Liberal leader announcing a summit scheduled for this coming Monday on the need for better proof of vaccines, and has invited major party leaders, including Premier Doug Ford, to attend. So currently, the Blue Jays have announced that they will require fans attending games at the Rogers Centre provide proof of vaccination or a negative test result. So the new requirement will apply to fans, staff, and all guests aged 12 and older. And the same will be required for those attending a Raptors or Maple Leafs game at the Scotiabank Arena. With all of this being said, at this time, there is no clear legal authority from the federal or provincial government for a private residence, such as a condominium, to request proof that an individual has been vaccinated. And in doing so, it may put condominiums at risk to potential human rights complaints. Instead, until such time that there is legal authority, condominiums should continue to focus on implementing and upholding public health guidelines just to reduce the risk of transmission between individuals on the premises. So this would include screening all visitors, requiring all visitors and residents, including those who are fully vaccinated, to wear a mask and to physical distance while on the common elements. So we will be keeping an eye on all the news and updates regarding vaccine passports, and hopefully we'll be uploading an article to our website as soon as we do have some more information. So thank you, and I will pass you back over to Patricia.
Thanks very much, Shannon. I appreciate that update. It'll be interesting to see where we go in the condominium world on this, because obviously condominiums represent people's homes, so they're different than going to a baseball game. Next slide, please. So we do have a few polls for you, and what I'm going to ask is if we could put up the first poll question. We want to understand who's in our audience today, and so we're going to ask you first, what type of condominium community are you a part of? And we'll let you take a few seconds to answer that. And if we could close the poll. So majority of the people today with us are multi-story, and that's good to know because sometimes the solutions change or are different depending on the type of physical structure we have. The next poll, if we could put that up. How old is your condominium complex? Part 2 of this session, we'll also be talking about aging infrastructure. With the collapse of the condominium in Miami, one of the real concerns is, about aging infrastructure, but also non-well-maintained infrastructure or ignoring really important data when it comes to your infrastructure. So you see up on your screen an indicator of range of ages. So if we could see the results, okay, majority of people here are with condominiums over 30 years. Thank you. And the last poll is, how old is the majority of the population within your condominium community? This is also really important to understand who is in our community and how it correlates even to the aging condominium infrastructure. As we evolve our communities and we look at things like AODA, and the requirements under the AODA, we have to think about how we can affect compliance in a meaningful way. So what are the results of that poll? Let's see. Oh, interesting. So we have a really strong representation where the residents are between the ages of 60 and 80 years old. And so we'll see how this plays out. I'm going to turn it over now to John and Ashley, and they're going to take us through a more detailed discussion on aging in condos. Next slide, please. Please go ahead, John.
Thanks, Patricia. So just by way of some preliminary comments, that aging residents not only impacts the aging resident, but also their spouse, their children, family members, friends, neighbors, property management board members. And when Ashley and I talk about aging today, we're really talking about risk management. A lot of people will age well in condominiums, and not everyone will see or experience some of the issues that Ashley and I discussed today. And we don't mean to paint sort of a really grim picture of aging in condominiums. But as lawyers, our role is often to deal with issues that arise, and generally not happy things that come up. I've talked about my role as a litigator before, and generally speaking, nobody ever comes to see me for anything good. They've either been sued or they're contemplating suing somebody or suing somebody, and that's generally what our sort of discussion between Ashley and myself today will be with respect to risk management. But on this other flip side of that, aging is not just limited to mental illness and physical disabilities. We're not going to talk a lot about other aspect of aging, but some of the more positive things that we have give advice on and continue to do so are social events and physical activities and how they can be brought into the condominium community and things like that. But one of the first things that Ashley and I will talk about today is the Human Rights Code. With aging, one of the more serious things that runs parallel with aging can be an increased risk of disability, and you'll see maybe some increase in condominium communities within more elderly population, maybe a higher percentage of people that would identify as being disabled. And we look at the Human Rights Code, Section 10 of the code defines what disability is as far as discrimination is concerned. And the words "because of a disability" means for the reason that the person has or has had or is believed to have or have had any degree of physical disability, infirmity, malformation, or disfigurement that is caused by bodily injury, birth defect, or illness, and without limiting the generality of the foregoing, it includes diabetes, epilepsy, a brain injury, any degree of paralysis, amputation, lack of physical coordination, blindness, visual impediment, deafness or hearing impediment, muteness, speech impediment, or physical reliance on a guide dog or other animal, a condition of mental impairment or developmental disability or a learning disability, or a dysfunction in one or more of the processes involved in understanding or using symbols or spoken language, a mental disorder, an injury or disability for which benefits were claimed or have been received under insurance plan or established under the Workplace Safety and Insurance. So there's a wide range of disabilities that are outlined, or what could be classed as a disability under the code. And at the same time, people with disabilities are a diverse group and experience disability and impairment and societal barriers in many different ways. Disabilities are often invisible, can be episodic, and people sometimes experience periods of wellness and periods of disability. And as you will see, that people we discussed today, people with disabilities have the same rights to equal opportunities under the code, whether their disabilities are visible or not, which can often provide challenges to condominium corporations. So my first question to Ashley is, generally speaking, Ashley, what rights do residents have under the Human Rights Code, and what obligations do condominium corporations have under the code?
Well, there's various, but generally speaking, and everything I discuss today is going to be very high level. I could talk about aging and human rights for days. It's one of the specialties of my practice, but I'm just going to provide general information. So residents have the right to housing and services free from discrimination based upon a prohibited ground, such as age or disability. And corporations have an obligation to promote inclusivity, remove barriers, and respond to requests for accommodation. In this regard, corporations have a duty to accommodate up to the point of undue hardship. You'll see on the PowerPoint slide, there are a list there of some common situations in condos where corporations receive requests for accommodation. Another one is accessible parking, or parking closer to the entrance of the building or the residence unit. I'm just going to briefly talk about some of these common situations. With respect to removing physical barriers, the most common request in this regard is when a resident has asked the corporation for a ramp to be installed, or a lift, or for an automatic door opener to be installed. And pursuant to case law, if the area where the resident is requesting this accommodation be provided, if it's an area that's enjoyed by all of the residents, the corporation would have an obligation to pay for it. However, if it's an area that is only used and enjoyed by that particular resident, for instance, their exclusive use common elements or within their unit, the resident would have an obligation to pay for it. Accessible parking, although it's not on the list, I did see a question in the Q&A about it. I have seen accessible parking requirements in municipal bylaws. That's primarily where I have seen it. Generally where it's stated how many visitor parking spaces and accessible parking spaces need to be provided. They're also in site plan agreements as well for individual condominiums. When it comes to accessible parking, sometimes there's competing human rights issues, because if you have a large number of residents who have, let's say, mobility issues and would like a parking space closer to the entrance, you might not have enough to accommodate everyone. So you'll have to balance their competing human rights and try and find a solution that can accommodate everyone within reason. Other examples are living caregivers. Sometimes corporations have rules or provisions in their deck that require that the dwelling units be for a single family use only. And if unrelated caregiver is living there, that's technically a breach. But if that individual is there to assist the person so that they can continue to live in their unit, a condominium corporation would be required to accommodate them by exempting them from the application of that rule. I'm sure many of you are aware, I know some of the participants, I've dealt with this issue for you. Emotional support animals and service animal requests are very, very common in condominiums that prohibit pets, particularly dogs. This is a very specific issue, and it will really depend on the individual requesting the accommodation, their disability-related needs, and the manner in which the service animal can assist them with those disability-related needs. I think, John, there's also on the list here, noise, nuisance, and unusual conduct. And I know you've dealt with a couple matters regarding this as well.
Yeah, thinking back over the sort of matters that I've dealt with, one of the more sort of complex and sensitive issues was respect to a noise complaint, where after receiving instructions from a client to send a letter to a unit owner about noise coming from the unit, we sent the letter, and the response we got back was, very generally, thanks very much, but the noise that you claim is being made by a child that has autism. And I've tried 14 or 15 different ways to try and mitigate any of the concerns that the condominium corporation has. So when you have that type of response, you've got two things in play: the rights of the neighboring unit owner to the sort of peaceful enjoyment of his or her unit, and you've got the disability that's being managed next door. And you can't really favor one more than the other. And it creates a very sensitive situation for the condominium corporation, for the property manager, and for the lawyers, generally speaking, because the one wrong step or one wrong word can land everybody in the Human Rights Tribunal. So it has to be really tackled with a degree of sensitivity. And when those situations have come up, the first thing that I would generally do is invite the unit owner that's put the disability or the issue on the table to talk to the board and say to them, if you haven't made an accommodation request, and to the best of our knowledge you haven't, we would invite you to do so. And, we're happy to talk to you about any way that we can accommodate or you think that you need accommodated, and to try and resolve it that way. It's often a case where a hammer is not necessarily the best approach at all and should be avoided, but a sort of ease in and try and open a dialogue to see if there is very specific things that can help both parties and to sort of enshrine both rights and to make sure that nobody feels that they've been oppressed or that they're not being listened to. Ashley, you'd heard me say there just a few seconds ago about this accommodation request, and if a request is made, the condominium corporation has to do certain things, and we'll talk about that shortly. But what is an accommodation request, and what does it look like?
All right, so a person with a disability is required to make their accommodation needs known to the best of their ability, and this preferably should be done in writing. However, it doesn't have to be. And they have to make their needs known to the best of their ability to the corporation, which would be the entity providing the accommodation, so that they can make necessary arrangements. However, and this is, I think, something that perhaps a lot of condominium corporations are not aware of, condominium corporations as an accommodation provider have to be alert to the possibility that someone may need accommodation, even if they have not made a specific or formal request. In this regard, under the code and the principles and guidelines issued by the Human Rights Commission, condominiums as accommodation providers have to attempt to help a person who appears to be unwell or is perceived to have a disability by inquiring further, by making inquiries with respect to their needs related to a disability or offering assistance or accommodation. So if a corporation is, dealing with an enforcement matter and there's a inkling that this individual may have a disability and that their conduct is related to that, the corporation does have an obligation under the code to look into that further, make further inquiries. And I believe Bob, John, he asked a question with respect to, what documentation can the corporation request? What documentation can the individual seeking accommodation, what documentation should they provide? Would you be able to answer that?
Sure. Generally speaking, a condominium corporation has no right to be told or to be informed of what the actual diagnosis is. So if you picture the scenario where somebody has, I'm just going to pull an illness out of my head here, it's schizophrenia, and they need accommodated because of that mental illness. You have, as a condominium board, have no right to know that they have a diagnosis of schizophrenia. What you are entitled to is, for example, a doctor's note that says that there is a disability and that certain accommodations are needed. And that's often a hard fact to accept, that you have somebody coming to you and saying, I need all these accommodations, or I need this one particular accommodation, and you're having to then be put in the spot where you're considering making certain accommodations because of that, and you're not maybe in your opinion fully informed as to why you're having to do those things. And it's really a balancing of the right to privacy and the right to the accommodation. But there is a policy, and I believe Julia will touch on that in her segment, that was released in 2016 that really reformed what people like employers, condominium corporations, etc., can ask for, and it's basically ruled out requiring disclosure of a particular diagnosis.
Sorry, go ahead, just Patricia. Jump in here for a minute and just also say that, there are also a lot of people that self-diagnose and tell condominiums what they believe they need without the necessary backup or material from a professional. So I do think that professional opinions here do have some value in terms of finding the right solutions. I think condos do have to do some due diligence here to make sure that, what is being prescribed is actually an appropriate solution.
If I could just jump in before we go on to the next slide, Deanna, my apologies, has a question with respect to underground parking spots and what to do if they're unitized, and how does the corporation accommodate a resident in that particular situation. Some newer condos are addressing this in their declarations, but that is something I wouldn't be able to provide an off-the-cuff response to. That was something that your corporation would have to seek advice on from your solicitor. And Bob also had another question with respect to a one pet rule. What if someone has a disability and they have a service dog that assists them with their disability related needs, and they also have a cat? Is the service dog considered a pet for the one pet rule? And the answer would be no, because if the pet was, then that would be discriminatory, because that individual would then be denied the equal opportunity from enjoying having a pet, being the cat, at the property like all other residents are entitled to have.
Because service animals are really tools, right? They really are helping somebody have a level of independence or support. They're not the same as a pet.
Yeah.
Okay.
I think we're going to move on now. There's a lot of more questions. Hopefully, we're going to try and make time for the questions at the end, but we'll move on to the Condominium Act discussion now, if that's all right with everyone. John, do you mind if I just go into it?
Absolutely. Go right ahead, Ashley.
So some common situations that arise, and I'm sure the property managers who are here today are aware of these. One is loitering on the common elements. Sometimes residents who potentially have dementia or sundowners, which is a related condition, or Alzheimer's, might be seen from time to time, wandering around the common elements, perhaps without a purpose. And this is a bit controversial because, they do have a right to enjoy the common elements like any other resident or owner. And even if, some other residents might find their behavior or their conduct, they might not like it, but they do have a right to enjoy the common elements. Now, when a corporation has to step in is when, the residents use the common elements by wandering around. It appears to it could endanger their safety or the safety of others at the property. Most commonly, we get notified by property managers that, a resident's walking around outside in the middle of winter and they're wearing shorts and a t-shirt. That is something when the corporation would have to step in, because that would be a threat to their health and safety. A lot of the time, residents also request, supers or security staff to help them with some personal matters in their unit, perhaps, moving something or getting something up high if the resident has limited mobility. And, everyone wants to be a caring neighbor and, a good employee, but being a good employee in this particular instance means, respecting the limits of the corporation's duties and objects, because as a creature of statute, the corporation cannot and should not do anything beyond what it is permitted and required to do under the Act. So if a super were to assist a resident from time to time with personal issues and matters in their unit, this could expose the corporation to unnecessary risk and potential liability. So if this does happen, it's good for the property manager or the board to have a discussion with the resident and also provide them with a written letter, just letting them know that that particular agent of the corporation and other agents are not permitted to do that, assist them, and direct them to community resources that might be of assistance to them. Sometimes corporations also get requests from family members who don't live at the property that, security go in and check on their dad that they haven't heard from that afternoon for 2 hours. The corporation can't do that. They can't enter a unit without notice in a non-emergency situation. So a corporation and its agent can't enter for the purpose of just checking on the resident's general well-being, nor can they provide a friend or family member who is not the resident's power of attorney with access to the resident's unit without obtaining the resident's prior written consent in a non-emergency situation. I emphasize non-emergency situation because John is now going to talk about when unit entry without notice is permitted in emergency situations, and what constitutes a dangerous activity or condition.
Thanks,
Take it away,
Ashley.
Tom.
So when we look at emergency situations, we're really looking at the provisions of Section 117 of the Condo Act that would allow the condo to act if it has reasonable grounds to believe that a condition exists that would or could cause harm to an individual or damage to property. And then under Section 19 of the Act, a corporation would be authorized, sort of in my opinion anyway, to enter the unit without providing notice. The question would become then what constitutes that type of activity? When I think of those type of activities, I'd be looking at, is there a flood? Is there water running in the unit? Is there a fire or a fire hazard in the unit that would allow entry? Maybe somebody suffering from a mental illness, and I think of dementia, but I don't really have any other illnesses that I can think of off the top of my head that would cause such a memory lapse, or they've left water running and they've wandered off and there's water coming through the ceiling, or there's smoke coming out of unit. Those situations would be situations that would have an emergency sort of attachment to it and would allow entry into the unit. It becomes a little more difficult when you have somebody calling up and saying, my dad is in unit 501. I've been trying to call him for the last 3 weeks. He never answers. It's very unusual for him. We have a standing arrangement for a phone call every other day at 5 p.m. He's not answering. I'm really worried about him. Could somebody enter into the unit and to check on him? And for those type of situations, it comes down to the facts and whether or not there should be an entry into the unit. It should be consulted with your corporation's legal counsel. It may be that the father just doesn't want to talk to his son or daughter anymore, or there's been a fight, and he's entitled to his privacy at the end of the day, and entering the unit to check on him may infringe on that privacy right. So even though there may appear to be an issue, it doesn't necessarily mean there's an emergency that would grant or permit somebody to enter the unit. Patricia, do you have any further thoughts on that at all? It's always a tricky one when we get those type of questions.
Right. Well, I also think it's, it's like you said, do the kids even have a right to call? Do they have a right to interfere? Because, unless they have an active power of attorney, I don't know who, if I was sitting in the property manager's position, I wouldn't know who else I could take any direction from or any instruction from. But I also wouldn't want to take on additional risk. I think this is what corps need to think about. By doing the extra steps, what other risks are you exposing the corp to? And should you be doing that? So I think it is a sensitive thing that boards need to think about and have a conversation with both security and property management on how to handle these kind of situations and create some boundaries, as to when it will be appropriate and when it will not. Because I think in an emergency as well, John, you have to act quickly. So you need to know in advance what you're going to do.
Yeah.
That's good. So speaking of emergencies, if we could please go to the next slide. So there are situations, as John discussed, when emergency action needs to be taken, so immediate action. So these would be the corporation would have to take immediate action when the resident is engaging or has engaged in conduct that poses an immediate threat to their safety or security of others or the property. Step one, call first responders, call 911. If the first responders aren't able to provide assistance and the issue or the activity or condition is related to a mental health issue, the corporation could contact their local police unit's crisis outreach and support team. And these support teams provide local area residents who are 16 years of age and older, who are experiencing a mental health crisis with immediate outreach and support. And anyone can call these outreach programs, and they're answered by trained mental health professionals who work there 24/7. If the corporation contacts the outreach support or if not a mental health issue, the corporation should then try and contact the resident's emergency contact person if they know of that, or a known family member or friend. Or if, potentially the owner of the unit if the person's a tenant, because the owner might know who to contact. And then the next step would be to contact your corporation solicitor, and if necessary, bring a court application, which John will discuss a little later on.
Ash,
Now
I'm just
in-
going to jump in here for 1 sec. I think this is an important point that you're bringing up, though. It would, in order to be able to have an emergency contact person, a condominium corporation therefore has to be proactive. It actually should be soliciting this information from its resident owners and keeping it obviously confidential and part of the unit owner file. But you don't want the emergency to occur and not have this data. You want to have some direction from the unit owner so that, you know, the necessary people can be contacted if there is an emergency.
So in non-emergency situations, it's advised that a condominium corporation, first contact the corporation solicitor, then try and contact the person's emergency contact person if it's known, or their next of kin. If their next of kin cannot be found or they don't provide any assistance, you can contact your local police unit's crisis and outreach support team if it's a mental health issue. Or if it's not, you can contact your local division of Home and Community Care Support Services, which formerly used to be called CCAC, and they provide guidance to individuals with respect to admissions to long-term care homes, and they also coordinate free and subsidized services for seniors to allow them to live in their home for as long as possible. So the corporation can request that the service provider dispatch a care coordinator to conduct a preliminary assessment of the resident's capacity and provide the resident with assistance. However, the service cannot help a resident without their consent or without the consent of a family member. And then, the last alternative would be a court application if necessary. And in that regard, I'll turn it over to the litigator, John.
Actually, now when we talk about court applications, really talking about compliance applications under Section 134 of the Act, and really when there is, for example, disability concerns or mental health concerns, they really should be the last resort to try and bring about compliance. When we think of compliance applications, we're asking the court then to order that the person who is causing issues or is causing damage or increases the risk of harm to stop what they're doing and to comply with the provisions of the Act and the corporation's governing documents. But when we bring those applications, when there's an element of mental illness, the court's going to weigh that up and say, look, there's this person here who clearly has a mental illness, or there's evidence of a mental illness, or in the judge's opinion, there may be a mental illness. And I don't know that I'm prepared to grant the relief that you're seeking without that person having a capacity assessment. And the court can order that off if its own bat. The judge can make a decision to say, I'm not going to do anything without this person first having a capacity assessment for two reasons, really. One, so they can understand the person that's subject to the compliance application can understand what the repercussions are, and two, to see if they are actually able to, in many cases, represent themselves, or do they need somebody to be appointed, like the public guardian and trustee, to represent their own interests. When we look at the compliance options, if there is repeat significant severe behavior, for example, if somebody is repeatedly causing fires in a unit or floods in a unit, or there's a severe risk that somebody will be hurt or harmed by a person's actions, the ultimate remedy would be to ask that they be ordered to vacate the unit, essentially to be prohibited from attending or living in the unit for any reason whatsoever. And again, when you're asking a judge to take away somebody's right to live in what's essentially their home, there has to be severe reason for that. And again, we're thinking of assaults, fires, floods, all of these type of activity. So that option is there, but there needs to be a significant paper record of all of the reasonable steps that the condominium corporation has taken leading up to that, and that certain behaviors can't be remedied. When looking at other types of issues that we see, you may be required to look at the power of attorney, for example, There's two different types of powers of attorneys: a power of attorney for personal care and for management of property. And it may be that the condominium corporation needs to have a policy in place whereby that's part of an intake, or a policy whereby when somebody is moving into the condominium corporation, that you can ask to say, do you have a power of attorney, and if so, can you let us know who that is. So if there's an issue that arises, you can get a copy of that document, and you can make the appropriate arrangements with your corporation solicitor for obtaining advice with respect to any request from the person that holds that power of attorney. Ashley, as our sort of corporate lawyer here, do you have anything to add with respect to power of attorneys?
Yes. So with respect to power of attorneys, if a resident contacts you, or excuse me, not a resident, if someone contacts you advising that they're the power of attorney for a resident, it's advised the corporation obtain a copy of it, of the power of attorney document, and then speak with your corporation solicitor, because depending on what power the attorney has, it could be either for personal care or for the management of the person's property, and it could apply only in specific situations or have limited, the attorney could have limited authority. So just call your corporation solicitor if you come across that particular issue. John mentioned, trying to be proactive and obtain the emergency contact and POAs from residents in advance. If you go to the next slide, please. There are also a couple other proactive actions that corporations can take. Contact your legal counsel, number one. They'll be able to provide your specific corporation with a sort of a toolbox of different policies and procedures that your corporation can implement to help protect your community and your property in this particular situation. One type of policy your solicitor will likely recommend is a human rights policy. This will ensure that requests for accommodation are handled in a timely manner and therefore do not cause the individual requesting accommodation with undue prejudice and does not expose so the corporation will not be exposed, to unnecessary legal risk. As Patricia and John mentioned, given that your corporation may be obtaining copies of powers of attorneys, and accommodation requests do involve confidential information, it's also advised that corporations implement an information management and privacy policy. And another thing that corporations could do is prepare an emergency preparedness and medical assistance policy or handbook. This can contain a number of different type of requests and information and policies, but it could just at the onset state the objects and duties of the corporation so that owners know and have a reasonable expectation as to what the corporation will and will not assist them with. It could list a bunch of preventative measures that residents can take within their units to help make their units a bit safer. It could provide them with information regarding their local home and community care support services division, as well as a list of the services that they provide. And it could provide residents with the contact information regarding their local police units mobile crisis support team. Another thing that corporations can do is be proactive. There was a question in the Q&A about a resident who requires the use of a wheelchair is frequently seen going to use the pool and the sauna. I believe the question was that how they have a difficult time getting in because of the width of the door providing entry to that facility. And should the corporation be asking this resident if they would like the corporation to modify the door so that's wider and or provide a chair lift for the pool. That's an excellent thing for your corporation to do. However, just touch base with your corporation solicitor first before reaching out to the resident, as you want to ensure that the language used is not offensive. It's not appropriate, to speak about someone with a disability as calling them a disabled person. That's not appropriate if they have a disability. So just make sure the language is correct. And also for your agent, your property manager or your super, you can provide them with mental health first aid. as well as human rights training, which is available for free on the Human Rights Commission's website. Yeah. So I think now we're going to turn it over to Julia, who's going to provide a bit of a case law update.
Thank you, Ashley.
You're welcome.
So just to recap what Ashley and John have discussed, in Ontario, condos are required to comply with the Ontario Human Rights Code and provide reasonable accommodation to residents who require the same, up to the point of undue hardship. In some cases, this means that conduct that would otherwise be prohibited under the Condos Declaration of Rules may be acceptable in order to accommodate a resident with a disability. So I'm going to discuss two cases today. One is an Ontario Superior Court case, and the other is from the Human Rights Tribunal. Both deal with accommodation requirements and the right to request medical documentation and evidence from individuals who are seeking accommodation from the condo. You can go to the next slide, please. Thank you. So the first case is Simcoe Condo Corp. Number 89 versus Dominelli. In this case, the residents didn't seek permission or accommodation from the condo to have a dog in their unit that exceeded the 25-pound weight restriction in the Corp's governing docs. The residents tried to argue that the dog was a therapy dog and was required for the resident's alleged disability. The court found that the doctor's letter provided by the resident was not detailed enough to establish that the resident had a disability entitling her to accommodation, and said that when dealing with a mental disability, a diagnosis of some recognized mental disability, or at least a working diagnosis or articulation of clinically significant symptoms that has specificity and substance is required. The court also commented that even if the pet owner, the resident, had established that she had a disability, no evidence had been presented that she required a dog weighing more than 25 pounds. So the respondents were required to remove their dog and pay the condo's legal fees. The next case is Collins versus Essex Condo Corp. Number 35. So in this case, the tribunal held a summary hearing to address whether the application made by Collins, alleging that the condo discriminated against her, should be dismissed. The tribunal was specifically asked to address the application of the Dominelli case. So the applicant had a service dog, which she said she required because of her disability. She moved into the condo and thereafter asked for the rules and policies relating to dogs. The corporation's lawyer contacted her and directed her to the Dominelli case and asked her to provide a diagnosis of a medical illness or disability to prove that she could claim to be a person that fell under a code protected ground. So the resident provided a letter from her physician, which stated that she required her dog to live with her due to her medical condition, and that the dog was necessary for her daily functioning for medical purposes. The tribunal considered the extent of medical documentation to be provided by individuals seeking accommodation under the code, and stated that the requirement of providing a diagnosis put forward in Dominelli was inconsistent with the Human Rights Commission's policy on ableism and the tribunal's case law. So the policy on ableism provides guidance on the scope of medical information that should be requested of a person seeking accommodation on the basis of disability. The person seeking accommodation is generally required to advise the accommodation provider that they have a disability, and the provider is required to take requests for accommodation in good faith. So under the policy, the type of information that accommodation seekers may generally be expected to provide includes that the person has a disability, the limitations or needs associated with their disability, whether the person can perform the essential duties or requirements of, in this case, being a resident with or without accommodation, and the type of accommodation that may be needed to allow the person to fulfill the essential duties or requirements of being a resident. So in Collins, the tribunal didn't comment specifically on the scope of the applicant's duty to provide information, and confirmed that the same would require evidence at a hearing where the application of the policy and Dominelli could be considered. However, the tribunal did say that the application had a reasonable prospect of success. The matter was set down for a hearing. However, the application was later dismissed as abandoned. So the takeaway from these two cases is that there's a balance to be struck between the right to privacy of a resident and the Condo Corp's right to information. So the requirement of providing a specific diagnosis put forward in Dominelli was held in Collins, which was released after the policy on ableism was adopted, to be inconsistent with the policy and the overall thrust of the tribunal's case law. So once a person seeking an accommodation makes the need for their accommodation known, the person from whom accommodation is requested, in this case a condo, is under a duty to consider that request. A person making a request does not have to meet an onerous standard for initially communicating that disability exists, whether it be a mental disability or a physical disability. So the Collins case confirms that a diagnosis does not have to be provided, but medical documentation that confirms that the person has a disability and the limitations or needs associated with the disability does need to be provided. So as always, we recommend that if you receive a request for accommodation, before taking any steps to ask for more information or medical evidence from the resident, that you speak with your legal counsel. And now I think we're going to move to some questions. So Ashley, I'll pass it back to you.
Okay, but before we get there, I just wanted to comment on this. This is very interesting. The two cases that Julia brought up show how tribunals actually, I guess, push public policy through their tribunal framework. The Dominelli case is a case of the Ontario courts, where judges are independent. They are not government employees per se, and they are basing it on the law. What I find troubling about the second decision is that it is that after the fact, policies are written, and then they are incorporated into the body of tribunal work to say that the case, which is a binding case, which is the case of the Ontario Superior Court, is not following the policy. But this is where you see how public policy, government decision-making, is being implemented into judicial type of decision-making. So it's always very important to be very cautious about this. I think Dominelli was an excellent case for condominiums, and the lawyer who argued it, Sonia Hodes, she did a wonderful job of helping condominiums navigate this area. I think it's really important that there has to be a balance between a request for accommodation being clearly established. For myself as a board member, where I've had this opportunity to hear requests for accommodation, my concerns about self-diagnosis have proven true. I've had a circumstance where somebody asked for a motorized scooter to be used in the hallways of the condominium corporation where I sat on the board, and yet attended the actual meeting with the board using a walker once or a cane. And the question was this: was it appropriate to have a motorized scooter in a condominium where we have other aging people and children? And, you know, the board had to find a balance there between the needs of other residents for safety who could maybe not get out of the way of a scooter quickly, and the fact that somebody could actually use a walker or a cane to get around. So I do think that I am concerned where tribunals overstep their boundaries and then implement public policy. I also wanted to, talk about something else just generally, is that aging of people and infrastructure is inevitable, and it's part of the cycle of life of both a resident and a condominium. From the Ontario Human Rights Council's research that forms the basis of OHRC's policy on discrimination against older people because of age, the council found that age discrimination is not seen as something that is serious as other forms of discrimination. Yet, despite that fact, it can actually have the same economic, social, and psychological impacts on individuals. Society has accepted age-based criteria as a way in which to structure policies and programs and to make decisions about people in such areas as employment and services. But we do need to be thoughtful about the fact that we may have stereotypes that influence our decision-making. Despite the fact that population is aging, many aspects of society have been designed in a way that is not inclusive of older persons. And I think in condominiums, we really have to be thoughtful about that. If we look at even the people that are on our call today, their communities range from 60 to 80 years old. That's a really wide range of people, but we need to include everybody. Preconceived notions, myths, and stereotypes about the aging process and older persons do persist and give rise to discriminatory treatment. So we, as well as condo board members, property managers, we need to bring this to our attention. We need to be aware if we have a bias or that we interpret being a senior or being older in a certain way, because it's not always true. What was great about some of the cases that we saw today or the discussion is that it could be any age. You know, the child with autism is a child. It's not an older person, but it was still impacting. It's still a human rights issue. So I think we also need to make sure that our policies are neutral. I think we've actually addressed a lot of the questions as we've gone along today. So I did really want to thank everybody on our panel. If you have further questions afterwards, please feel free to reach out to John, Ashley, myself, Julia, and especially on the corporate governance issues. We're happy to help you in structuring policies. It's really important that the corporation set itself up to succeed, that it has the right processes in place to have evidence on file, that it has made clear decisions that are based on, unbiased protocols, and that it is timely in its return and in answers to unit owners that are requesting accommodation. The other thing I think we all are aware of, and property managers more so than even legal counsel at times, is that condominiums are communities. We're trying to build that for everybody. So if you can provide your unit owners with resources, please do so. If they need help accessing information, we saw this through COVID. We saw people helping everybody in their community, didn't matter what their age was, find the way to get their vaccines, to get to those inoculations. We can do this for other things. There are lots of resources out there. There's actually a book put out by the provincial government of Ontario on resources for seniors. And so the condo itself, even though it doesn't have an obligation to help fulfill that knowledge requirement, can help in bridging the gap for unit owners. So this was part one. Thank you guys. That was really well done. I really appreciate your time and effort on this. I wanted to bring up to you upcoming CCI events. CCI has so many wonderful topics coming on board. Eastern Ontario, the relationship between board managers and owners. Toronto and the surrounding area is going to have Ask the Experts. CCI Huronia, we've got a Lunch and Learn webinar, and we're going to be discussing repair and maintenance. And we're going to talk about the collapse of the condo in Florida. CCI Grand River, the Reserve Fund studies, always a hot topic. Golden Horseshoe, duty to repair part 2. For those of you who are with us on part 1, it was an excellent look at what could happen, but now we're going to talk about how we break down those emergencies. Golden Horseshoe also has an introduction to condominiums. CCI Windsor is AGM and Ask the Experts. Golden Horseshoe again, this sounds like a good one. Days of Our Condo Lives. Everybody likes a good soap opera. So I would stay tuned for that one. CCI Golden Horseshoe in the Enhanced Directors Virtual Course Series is starting because CCI is doing a great job to raise the bar in director knowledge. And then CCI Grand River, their virtual conference and AGM is coming. Should be an excellent conference. The topics look really wonderful. So congrats to all the chapters for getting out there and making sure there's lots of education. Please share it with your boards. And thank you again for joining us on CondoWise. Take care and stay well.